Welcome everybody to our presentation here at Vincent Elkins on making sense of methane. My name is Ron Tempest. I'm chair of the environmental practice group here at Vincent and Elkins. We have three of us on the panel who are have significant government experience before being, or both before and after returning to private practice, so we hope you won't hold that against us. Our bios are generally in the packet, but for my purposes, I obviously do a lot of environmental work. It's compliance counseling and enforcement related work. A lot of that derives from a couple of senior positions I had at DOJ, including leading the environment division, which is the enforcement group that brings all of the federal court environmental cases. Seated next to me is Corinne Snow. Corinne is a counsel in our environmental practice group. She was also at DOJ at one point as chief of staff to the Assistant Attorney General, one of the people who served in that role after I had concluded. Corinne has been very active in following the development of these three collective rules. She also does a lot of work for individual companies and trade groups in commenting on rules as they're developing, working on the litigation that follows. And so she's been very closely involved in the development and continued development of a couple of these rules that are not yet final. Next to Corinne is Matt Dobbins. He's the only one who gets to say he's avoided the failure of serving in government. Matt has been at V&E from the beginning of his legal career and has been involved in scores that still may undersell it of oil and gas transactional matters, mergers, acquisitions, dispositions, financings. Is also very active in project development and regulatory developments on things like hydrogen, ammonia, and some of the newer green technologies and interests that are developing. So he'll be able to speak to some of the commercial aspects. And then Patrick Traylor is on the other end here. Patrick is a partner here at V&E. Also is a career, environmental lawyer in private practice and in government. He had the #2 enforcement position at EPA for a couple of years, which included notably overseeing all of the Clean Air Act enforcement portfolio that the EPA had during the period he was there. And so that included enforcement activity related to the original Quad O and then Quad OA, and now obviously can bring that experience to bear as we face some new developments in the Quad series. So one other just opening comment in terms of what we're going to try to do today. We were enthused by the number of people who were interested in attending. We were daunted a bit by the range of responsibilities that we see reflected in those that are here. So we have folks who are participating who are, at kind of the senior suite level, CEOs, CFOs, general counsels who obviously probably care more about the general terrain and some of the larger commercial implications. We have folks who are in assistant and deputy general counsel roles and heads of HSE who are probably a little more interested in some of the specifics of these rules. And then we have some operational folks who are non-lawyers. So that presents a bit of a challenging audience, but what we're going to try to do is serve up a little bit, at least a little bit for everybody, and hope that you all have found something worthwhile to hear about. So to kick us off, we're going to turn it to Corinne, who is just going to try to give the broad overview and summary again of what are these three different rules. And just to emphasize, there are three different regulations finalized or in the process of being finalized that all pertain to methane. They intersect and come together And so we want to just make sure we've got a foundation on what those three different elements are. So Corinne, why don't you take us away?
Yeah, so three things going on here. You have a methane rule that will impact what exactly you can do at certain facilities that are covered that just became final last Friday. You've got your greenhouse gas reporting rule, which has been in effect for a number of years now, but EPA is currently proposing changes to how you're going to do that reporting, which we'll talk about timing on that. And that's still at the proposed phase. And then we have the waste emissions charge, the methane tax that was introduced in the Inflation Reduction Act is now part of the Clean Air Act, which is in effect for this year. So in 2025, you're going to have to report on 2024 emissions. EPA has put out a proposed rule on how it's going to implement that, because right now we just have statutory text without a lot of guidance on what's going to happen. On that one, the comment period is still open. So you still have until March 26th, not a ton of time, to formally let the agency know if what they're doing doesn't make sense for your operations. And I'm just going to briefly talk about each of these three rules to give you a sense of what they cover and how they interact with each other. So first one is what is colloquially called Quad OB, Quad OC. This is, again, direct regulation of the emissions from certain oil and gas facilities. And I'll flag here that facility is a defined term under all these regulations. So it's not necessarily what you would think of as, okay, this is my particular facility. It has a regulatory definition. And to make things more complicated, it has a different definition under each of these rules. With some overlap. And so that's something you're going to want to pay attention to too, in terms of looking at these and how they comply. So this isn't just about reducing your methane emissions, but it's about doing it through the specific ways the EPA says in its rules that you have to do it. There have been prior iterations of this regulation already, but this is the first time where EPA has also introduced not only more stringent regulations, but regulations that will also eventually cover what are called existing sources. So much of what is triggered here depends on when a facility is introduced as new or is modified based on what the regulations consider to be a modification or is reconstructed. So another thing to flag here is folks are going to have to be very careful about changes made to their operations now so they don't trigger that modification requirement. And why that is so important is if you are a new or modified source under these regulations, they apply to you starting May 7th of this year. So not much time to come into compliance. If you are existing, if you have not triggered that, it will be years before these apply to you. First, the states have to submit plans to do this, and then the states can give you up to 36 months after their plan is approved by EPA to come into compliance. So again, those triggers and knowing whether you are new, modified, or reconstructed, or whether you're existing is going to be incredibly important. Some of the new requirements here, just at a high level, are they've introduced what's called a super emitter program. And so there's going to be third parties, not EPA, who can come in, and if they think they have evidence that there's been a large methane emission from your facility, they can report that to EPA. If EPA thinks that it is valid, then they will turn around and give you notice. You'll have 5 days to start an investigation, 15 days to report back to EPA, and everything will be made public about that. Brand new program, and as I'm sure Patrick will touch on, going to raise some enforcement risks for everyone. They've also introduced some new tank requirements, which are going to bring in a lot more tank batteries than were previously covered by this rule and make it a lot easier to modify or to trigger that modification requirement. They're going to make you go to a zero emission for all of your pneumatic controllers standard. And then they're also going to really curtail a lot of routine flaring of associated gas. And again, just to give you a sense of how complicated this is, how a lot of these are triggered is very based on the dates during which your modifications or when your sources were introduced happens, you are either probably the guy or have a guy who is deep in the weeds on all this. I hope you are not the guy, but the important thing to know here is you should be talking to your guy, right? And making sure that he is on top of all of these changes and that he's understanding how these rules interplay, and that he's also talking to your operations folks, your business folks, your legal team to help everybody understand how this is going to impact operations going forward. Second rule is on the greenhouse gas reporting. This is another existing program that's been around for a few years. But in the past, the stakes here were pretty low. It was you kind of did your best to estimate your methane, your greenhouse gas emissions from your facility, differently defined here than in the prior rule. And your facility here, especially if you're in upstream production, it was on a basin-wide basis. So you aggregated everything. If it was more than 25,000 tons per year of greenhouse gases, you had to report. Where you couldn't exactly get numbers right because it's hard to measure some of these things, EPA had formulated a number of ways for you to basically guesstimate. Congress told them you need to be more precise in how you do this, change it up, and also Congress decided this reporting was going to be the basis for what you pay for the waste emission charge, the WEC, that we'll talk about in a minute. And so suddenly the stakes here are much higher, right? Because it's going to impact the tax you pay. And if you get it wrong, there are all the penalties involved in the WEC that will follow from that. To make things more complicated, just as you are trying to get your arms around the WEC and what you're going to have to do there, EPA is proposing to change the way that you report your emissions, which will both mean that compliance folks are trying in the first instance to figure out what they're supposed to do under these new requirements, what additional sources they're supposed to be measuring. And it also means, from everything we've seen, that what you're reporting will probably be much, much higher than in the past. Not surprising, as soon as the government starts collecting money off of something, they've decided that they're going to need to make that number as big as possible. And so this is where we've gotten the most interest recently, the WEC, right, the methane tax, and what is this going to mean for everybody? As I said, it starts this year. The amount that you pay will scale up, and it's based on your methane emissions that are above a certain threshold per facility. And again, this is a slightly different, although it seems similar, definition of facility to what we have under the greenhouse gas reporting requirement. But there's some ambiguity in what EPA is proposing to do here, so this too could get a little complicated for everyone. But essentially what they're having you do is figure out your methane emissions and whether or not you're above or below their particular threshold on each of your facilities. And then once that number could either be positive, negative, or zero. You can then net across all of your facilities that, as EPA has proposed it, have more than that 25,000 tons that would be reporting under subpart W. And by netting, you could potentially decrease the overall amount of tax that you are having to pay here. There's also 3 exemptions that were in the statute that we can get into further, but the main thing to know here is EPA has essentially introduced a lot of new requirements to use those exemptions and new requirements to use the netting that will essentially make those exemptions, I think, nearly impossible to qualify for. So people, I think, had been kind of hoping, especially if they were in compliance with Quad OBC, that they wouldn't have to be paying this tax, and EPA is actually going to make that quite challenging to do. And just to give you a sense of the WEC and how complicated it is, EPA has introduced for everyone this simple 8-step plan to figuring out what exactly you have to pay. So again, this is a place where you're going to want to get folks from a bunch of different teams together to sort of understand the interaction of all these rules and try and figure out what exactly you're going to be paying.
All right, so that's the simple overview. I guess not everybody in the room is old enough. Not everybody in the room is old enough to remember it, but there was that famous moment when President Clinton's proposed healthcare plan was announced, and there was the chart with 27 different sprawling things. EPA has not done a lot better, both in simple things like what's the analysis for related flaring or what's the analysis for the WEC. So, but hopefully that gives folks some general sense of both where these things intersect and where they stand in terms of development, because one of the challenges, I think, as Corinne alluded to, is some of these, the substantive requirements for controls and how you conduct your operations kick in very quickly, within a few weeks of now. Others are still in development, but you're going to be expected to, your operations even this year are going to be affected by these rules that are not yet even finalized. So it is a bit of a dynamic and complicated posture right now. All right, so we're going to turn a little bit now to enforcement and broadly what has been going on in this sector, and then project forward a little bit about where are some of the places where if there is a mistake or you find yourselves unable to kind of quite meet the standards or timelines that EPA set out, what that can potentially look like if the EPA and Justice Department get interested. So Patrick, that's your cue.
Thanks, Ron, for the introduction. Thanks, Corinne, for the overview of these three rules, because they're all going to begin to increase enforcement risk once they're finalized and the EPA understands them and begins to ensure and see to it that people comply with them. Normally, I'd like to walk around the room when we give these kind of talks, but I've been admonished, keep your seat in the seat, right? So I can't walk around. Maybe people online would appreciate not just having an empty chair here. But I do want to encourage questions. So as I go, if you've got a question, I don't have a set piece presentation that I've got to get through slide 1, 2, and 3. If you've got a question about enforcement or anything that I've said, just, pop your hand up and we'll just address it right there. Likewise online, if I say something that interests you and you've got some sort of follow-up that you'd like to pose, please just use the chat feature. The questions pop up right here on a screen that we have, so we'll be able to address those instantly. So please, begin to think about the kinds of questions you might want to ask in terms of enforcement. So with that, let's go ahead and at least begin the slides. I hope you interrupt me soon from this. It'll be more fun for you to interrupt, 2 or 3 slides. So I think it's important to say that EPA broadly, but in particular, the EPA regional offices that are located in places like Dallas and in Denver in particular, have been aggressive on enforcement of clean air requirements at oil and gas facilities for almost a decade. They started off, Noble Energy was the first settlement way back, 2015. Essentially, as soon as Quad O, the original Quad O rule became effective, EPA enforcement began sending out inspection teams, began taking a look at upstream operations, began, quite frankly, to educate themselves. How do these little small facilities out on the landscape work? They know how refineries work. They know how manufacturing works. They had to develop, and it took some time to develop some internal capacity to understand how an upstream oil and gas production asset works and doesn't work from the point of view of excess emissions. So they began that work right after Quad O. You should understand, though, that with this new rule, they're going to do the same thing. They're going to go through this learning phase. Well, how does Quad O-B work? But the learning curve is not going to be nearly as long for them with this decade of experience. And they've got engineers and air inspectors all over the country who know precisely what to look for. when they're looking for excess emissions and so forth.
All right, so Patrick, I've got a question.
Yes, go for it.
The regulation comes from EPA. How can EPA itself have a learning necessity? Do you want to talk a little bit of difference between the people who write the regs and the people who enforce?
Sure, yeah. It is odd to think, right, that the agency doesn't know how these units operate, nevertheless, they're willing to regulate them. But that is in fact what happens. Especially with Quad O, which was sort of a first of its kind sort of a regulation. I don't know how many of you have dug into all of the regulatory background documents for that original Quad O and Quad OA rule, but it was very clear that EPA was learning as it was going in terms of how these facilities operate in real life. And even today, after now the third iteration, if you include Quad OC, the fourth iteration of these rules, the rule writers are people of good faith and good conscience, and they're just doing their job, but they don't make a living operating oil and gas assets. They simply don't and can't understand all of the details associated with how they work. So then when enforcement comes around, enforcement has to sort of figure out, what does the rule say and what does it mean and what could it mean versus what they're actually seeing in practice out in the field. So these rules leave it to enforcement in an odd way from the outside. Enforcement learns more about how things work in practice, in real life, than the program office, the rule writers do. So there is a learning curve where enforcement has to learn even more by reference to what's really happening in the real world.
And, to that same point, EPA is certainly not a taxing authority. So when you think about the WEC, right, the enforcement folks are not going to have any idea what to do here. And in fact, in the proposed rule, EPA has even proposed that you will have to go out potentially and find an auditor and pay for an audit yourself to help them out here, which gives you a sense of just how much they're not quite sure what to do with this program.
I see some puzzled looks. Yeah, questions about that point? Oh, there's a microphone right there to your right.
My question is on the WEC. You mentioned you had three different parts, right, in terms of reporting. On the WEC, are they going to be assessing on existing facilities, or do they have a runtime of 5 years before they're going to be?
No runtime. The runtime is only for the quads, the Quad O BC program for the Cs. On the WEC, it is everything that is already reporting under Subpart W.
All right, we have our first online question. Here it is. Is there a current legal interpretation of gas lift volumes as an applicable item in facility, quote unquote, throughput to use as a basis to calculate the waste emissions threshold? I would be cruel and bounce this to Corinne, but I'm not going to be. I don't know the answer to that question. I'm sorry. If, we can look into it, you can reach out to any of us and we'll be happy to engage offline. This is a really complicated rule, and you're going to stump the chump sometimes when you ask these sorts of detailed questions. So that one, unfortunately, I don't know the answer to. Corinne, maybe you do.
They have a proposed way that they're going to deal with it, but we won't know until the rule is final how this is actually going to work.
And as long as we're here, we may pick up another couple online. So for upstream operators, the question, how will the methane tax work for a non-operator, e.g. operator owns 50%, non-operator owns 50%? Matt, I think we may have anticipated some of this would come up. Do you want to defer on this, or do we want to jump in right now, or Corinne?
Well, I was going to say Corinne was not your head so if you would like to go first, and then I can supplement. But in general, right, and what Corinne will tell you is who pays the fee tracks the definitions in the rules. And so if a non-operator is not captured in the definition of owner and operator of an applicable facility, the non-operator doesn't pay the tax, right? They don't have the tax obligation, but.
Yeah, so EPA has proposed that they've introduced a new term for the person who's going to be responsible for paying the WEC. And basically everybody has got to get together and decide who that's going to be as between, your owners, your operators, your non-operators. They seem to be wanting to track who reports under subpart W, which uses owner-operator in their definition. But again, this is one where it's still muddy and we don't know what's going to happen. And it's not clear, EPA clearly knows what they want to do either.
Yeah, but I do think there's low risk of non-op holders getting pulled in part because when you look at who is the owner operator of onshore oil production, right? As that's defined under subpart W, that's tied to who has the drilling permit, essentially, right? So again, there's not a whole lot of room to capture in these non-op interests. I do think it's an interesting question, right? Of, okay, what is the non-op operator or what's our non-op share of the fee? Is that clear in your joint accounting agreements, right? Is that very, something that may have to be worked out? I don't know that we've sat down and thought traditionally, okay, here's what the non-operator is responsible for. Does the WEC charge actually fall into that cleanly? Is it an open question where it could create some litigation risks for our oil and gas litigators? I think to Corinne's point, the rules are not clear enough that even if a non-operator is not going to have to necessarily pay, there's still lots of kind of outgrowth of risks coming out of these.
All right, so I'm going to tee up one more of the online questions, and I'm going to kind of flip us back a little bit, and maybe we can get through some of the basic information, and we'll go back and forth in terms of picking up some questions. So, Patrick, as long as we're on enforcement, there is a question here. Is there any concern or history of the EPA enforcing provisions of a new regulation while states are in the process of assuming jurisdiction? For example, is there any concern that EPA would enforce for violations of Quad OB while the states are still in the process of getting their infrastructure in place as to their overseeing of these requirements?
Yeah, it's a really good question, and it's one that goes to the heart of what's described under the Clean Air Act as cooperative federalism. Under these NSPS programs, EPA has primary enforcement jurisdiction because these are federal standards. So from day one, on May 7th, when the requirements, when the deadline for compliance comes up, EPA has primary enforcement jurisdiction to begin to ensure compliance with the new rule. Under the NSPS program, states can opt in to adopting the EPA's rule by reference. They can say, hey, you know what, we would like to enforce and implement Quad OB. You have that around a bunch of states will enforce a lot of the NSPS rules, not just these oil and gas ones. If a state elects to do that, then the EPA and the state have concurrent enforcement jurisdiction. If a state doesn't elect to adopt the NSPS by reference, then only EPA has enforcement jurisdiction. When you have concurrent enforcement jurisdiction, things can get tricky as between the EPA and the state. Who's going to go first? Who's going to bring this case? Is the state being aggressive as EPA would like them to be? And then that's where you get some sort of the government side friction between states and EPA about, who's going to actually enforce suspected violations of the act. So that's what it looks like in the context of concurrent enforcement jurisdiction under the NSPS.
So fair to say there doesn't look to be a safe harbor that if you're in a state that's still deciding whether it wants to join into the NSPS, you can't sort of rely on that because EPA is free, and I don't know whether you would say is likely to begin its own investigatory and enforcement work.
Yeah, for states that are still deciding, EP enforcement is the only game in town. And then even once states take over, if they decide to, adopt the program, EP enforcement is still likely. It's just a conflict between the state and EPA about who'll have the lead, right, on the case.
All right. So Patrick, why don't, let's see if there are other high points you want to hit as to enforcement. I know you've got some trend data also to just
Sure.
Give people a sense of this. We'll address a couple of those things and then we can come back and pick up some additional questions.
Sure. So, like I said, EPA has been doing this for about 10 years. They've not slowed down. They were doing it before I got into the EPA. They continue to do it now. Just a brief order, what do you mean doing enforcement? What EPA typically will do is it will either conduct boots on the ground inspections of oil and gas facilities by inspectors in the field, or more typically commission helicopter overflights using forward-looking infrared cameras to detect emissions from unlit flares, thief hatches, pressure relief valves, mistuned engines and combustors and so forth. And if EPA gets evidence of actual visible emissions using the FLIR cameras, then they begin an enforcement case. It could be administrative, it could be civil judicial, depending on how widespread and how much evidence and how many facilities. But EPA will typically start these cases with, an evaluation of actual emissions. But once they have you in the crosshairs, the case expands really quickly to asking for copies of all your permits, asking for copies of all your Quad O and Quad OA, and now soon Quad OB compliance records and so forth. Once EPA digs in, particularly on the civil judicial enforcement track, they look at everything top to bottom in terms of your compliance. So that's just one way to think. So if you begin to get letters from EPA, hey, we overflew your facilities and we found these, you know that you're on the beginning part of that process, and you should begin to pay very, very close attention to what happens next. So that's the general process. Let me just go on here and then talk about the costs of these settlements. And I think maybe pictures are better than words. Here's the chart. From 2016 to 2024, these are the cumulative judicial enforcement costs that EPA and DOJ together have imposed on upstream oil and gas facilities. We're coming up on $100 million worth of costs. And this chart doesn't include Noble. Noble was like another $90 million, right? So we're actually getting up to about $200 million over a decade in terms of people not doing it right according to EPA, and EP enlisting DOJ to come in and cause those companies to spend money to return to compliance. And I wish I could tell you the rule was, oh, just come back into compliance, just follow the rules. No. Once you're in this situation, EPA and DOJ will write a bespoke compliance program for you that goes well beyond the requirements of the regulations and law, under the theory that, well, you've messed up, we don't trust you, so now we have to make sure we put even more sideboards so you don't even get close to non-compliance. That's why these costs can get so high. These include civil penalties, capital projects, projects to offset old excess emissions. It's kind of a whole ball of wax here in terms of these costs. These are not small numbers. And a lot of companies, they're operating, maybe they don't have a good sense of their compliance, maybe they don't have a good sense of emissions and design assessments for storage vessels, and maybe they think, yeah, it can't happen to me. With helicopters flying all over the place, EPA is now making a second pass through North Dakota and the Powder River Basin. They've been very vigorous in the eastern and western Permian. It's unlikely that EPA is not going to find out problems going forward. So folks should just be aware that the costs of getting this wrong and not being in compliance are growing, and they will continue to grow over time. Yes, sir.
Sorry, two quick questions. On this graph, is that like a year-over-year growth? I mean, in 24, there were 90 million, or is that cumulative?
Cumulative.
Okay,
Yeah,
cumulative.
every new settlement adds a little bit to the stack, and
Gotcha.
these are all in 2024 dollars.
And just for clarity, did you say that if you are caught or persecuted, you're saying that DOJ and EPA can force you with a custom compliance system that goes beyond what the regular regulatory
That's correct.
provides?
That's correct.
Okay, thanks.
Yeah. And they triggered the courts, so it's a civil judicial case. So they rely on the court's, inherent equitable authority to sort of generate remedies that do justice, right? So if it's beyond what regulations require, beyond what the black letter law requires, courts always have the ability to fashion remedies that ensure that justice is done.
Yeah, and I'll add there, I mean, the practical dynamic of those discussions and negotiations is the government has a view that if they were forced to sue in court and they proved the violations, then the court would have a very broad power to order you to do more than just come back into compliance and pay penalties. I will say, I think that's a disputed proposition within the environmental litigation bar. Not everybody would read it so broadly, but the practical force of that is unless you are really willing to say to them, we want to go to trial and we will go to trial, you are negotiating, probably are looking for a settlement. Maybe you'd be willing to go to trial, but nobody's really done it yet on a big Quad O. And so in some sense, they can't force you. You can always say, no, you're gonna have to sue us. But there's so much leverage there because it's so consequential for a company to think about, a multi-year civil enforcement matter that the dynamic is essentially that they can demand that, and companies generally find themselves kind of yielding to that demand. All right, so let's move on a little bit. Matt, why don't you talk a little bit about this as a commercial transactional lawyer and the things that you're telling people to start thinking about or you're worrying about for them?
Sure. So I'm going to level set. I'm going to talk a lot through the lens of upstream M&A agreements and midstream M&A agreements. Obviously, there are other industry segments that the WEC applies to and other industries that are involved here. But I deliberately chose upstream and midstream M&A as the lens because upstream has some very specific environmental mechanics built into the contracts. It's what's considered market. And so adjusting those provisions is going to be a lot more complex than just dropping them into agreements that don't already have a lot of formalized environmental mechanisms. And I would put midstream M&A generally into that second category of not a whole lot of formalized environmental mechanisms. So again, everything we're going to talk about is universally applicable, but I'm doing it through these two lenses just to show some contrast here. Now, here we are, March, we're almost at the end of the first quarter of 2024. And if any of you on the line or in the room are scratching your head saying, oh my gosh, I've done multiple deals already this year and I haven't thought at all about any of these, have I messed up? The answer is no. And in fact, that's still consistent with what we're seeing in the deal-making space. People are starting to pay attention to this. They're wondering if they need to address it. But in part, think about where we are in the year, right? For a lot of people, we haven't hit enough time yet where we're talking about a material amount of money. A lot of companies I talk to, most of them have still really only done back of the envelope WEC calculations, even though now we've got a real rule and some guidance from EPA on it. But generally, most people for their 2024 payment due in 2025, I've heard estimates ranging from 8 million to 20 million. So not insignificant, but not necessarily transaction changing or shattering, particularly given the deal size we've seen over the past year plus, right? So I don't think anybody's been wrong to not focus on this yet or include it. And in fact, if you're like, well, do we really deal with environmental regulations routinely and specifically in the mechanics of our transaction agreements? If you're thinking the answer to that is no, you're not necessarily wrong, but there's something I do want to kind of put into context, right? So the EPA GHGRP, it's been around since, gosh, now we're coming on 10 plus years, almost 15, I think, more or well, 15 years since the Congress passed the law saying EPA do this, and a little less time since the rule came. Right. Well, when the GHGRP first came out in Subpart W, you actually did see at least reporting covenants put into upstream and midstream M&A agreements, they were fairly simple. They were fairly simple in the sense it was, okay, after the sale, within 90 days of closing, you, buyer and seller, will go update your certificates of representation in EPA's system, EGRIT. At least that's how I like to say it, because then I think of the bird. But now, over time, right, it became a lot easier to manage all of this stuff. And so you saw those provisions kind of fall by the wayside, and general reliance on the parties will reasonably cooperate to notify agencies and make transfers. And I'm not even saying that we will never be in a place where we can rely on some of those broad general positions. But right now, since this is all so new, clarity is what's going to be the most important for making sure that we don't have open questions on liability and transactions. And so putting in some bespoke provisions, pushing the envelope on what's normally considered market, I think really is going to be important here. And that's going to create a tension, right? I can't tell you how many times a client will call and say, we found this environmental problem. We found this regulatory compliance issue. Write us a special covenant to deal with it, or a rep and warranty. We put it in there, it's promptly rejected. And why? Because the seller says it's off market, you're covered by this, you're covered by that, I'm not dealing with this. So we're gonna have highly negotiated points coming out of this. I wanna prep that with everybody. This is not a simple kind of select from a menu of options and everybody will generally agree the menu is what's fair and reasonable for both sides. Now on this slide, I've got up here what EPA and their subpart W proposed revisions has identified as the general 4 buckets of transactions. The real kind of takeaway from here, I would say, are 2 things. One, even though I mentioned the general requirement to update your certificate of representation within 90 days of a change in our Birdie online platform, the EPA GHGRP regs did not really historically have a lot of detailed provisions on how to address ownership changes. Now we've got something and a little bit more guidance from EPA. And so that to me, again, signals, all right, we need to start aligning our contractual guideposts with some of what the agency here is thinking on obligations. And now why does that matter? Well, you know, I think it's very important, as you'll see in the next slide, even though regulatory reporting and payment obligations are definitively transferred to certain people if they meet certain circumstances, you still are going to have some inherent risk, right, of who's responsible for what. And by adding in additional contractual protection, say you lose on getting a nice indemnity for XYZ issue. Well, if you get a covenant on they must report, they must update, and they fail to do that, that's another potential indemnification claim you can bring. So I'm trying to convey that we're going to have a mixed menu of options here. And it's important to try and think about which ones make sense and what might also be a little bit extra that can still provide some coverage and protection on these issues.
And I'll say one of the things that Matt is going to have to fix for people is the fact that these rules don't really talk to each other properly. In fact, they were drafted, some of them by different offices within EPA. And so definitions don't line up, responsibilities don't line up. And so those are issues that are going to have to get handled on the back end in these transactions.
No, that's a great point, Corinne. And so you'll see on these slides, I've usually got like facility or owner and operator either in quotes or star. That's because, again, it's different on each program, right? Now, when it comes to drafting, we can draft high-level provisions. We don't necessarily need to cite specific regulatory provisions on some of this, but it's still important to understand where the differences are and what happens here. But this slide I like because this is a good outline of some of your basic covenant obligations that you would want to put into an M&A agreement, right? It's going to say, okay, if somebody is the owner as of this date, they are reporting GHG emissions. If someone is the owner or operator at this date, they are making the filing. This is not enough though, but this is a good starting point to just understand again, kind of what the timeline, the cadence of obligations are. And each of these, at least the concept of them, is going to go into an agreement and you'll need to flesh it out and build it out more. And so what do I mean by that? Well, look at the WEC revisions piece, right? Now, we're not feeling our way through the dark here because there are concepts borrowed from transactions under GHG cap and trade programs where you kind of have effectively a tax, a little bit is due at one point. There may be a verification period where you then realize you underpaid and you need to make whole or do a true-up payment. EPA's isn't quite like that, but again, I'm just trying to highlight there are some analogies we can borrow from different regulatory programs that already are kind of out there in the transactional universe. But so figuring out, okay, WEC revisions are due by November 1, I probably need to build in a covenant for a true-up of any, underpayment that's been made. I need to think about how to address fines and penalties for any underpayment, right? Because as Corinne and Patrick have noted, the EPA is going to find different ways to make this painful for you if you don't follow their rules, regardless of how clear they may actually be. So, one other thing I think that's important to kind of keep in mind here is, again, who is the owner and operator under each specific rule requirement, right? And the rules very specifically say, if you're in the transmission segment, you are the owner and operator if you have this. If you're in the gathering and boosting segment, you're the owner and operator if you have that. So again, this is not necessarily something to address in the drafting, but it's important to just keep in mind, you're probably going to have a couple different players in place. And when we get to the next slide, I promise I'll go into a little bit more detail about how I've envisioned some of this coming out and tripping up some people. Okay, so I'm going to talk a little bit, step back, generally about how M&A agreements are set up in the upstream space and the midstream space. In the upstream space, we have what's called an environmental defect mechanism. This is usually paired with a tidal defect mechanism too. And what's unique about it is, historically, very little to no environmental due diligence was done prior to signing. Your environmental due diligence happened during your defect period, which is your interim period between signing and closing. Now, for lots of reasons, right, parties may want to make that period as condensed as possible because they want to get their money. I've seen, the defect period shrink from 60 days to we're not quite at 30, but that's certainly where a lot of sellers are really going to push it. Usually 45 days is where you end up. That's important because that's going to dictate how long your internal team, any external consultants, and your legal advisors may really have to dig into some of these issues. So planning and scoping diligence is really important because some of those constraints that generally exist in an environmental defect process, they're not going to go away just because we have this WEC, just because we have all these other new rules in place. So I think you can run into some real timing points, and Patrick and I have connected on several deals where it's just like we did not have time to look at this, or we wanted to look at it and seller would not budge. And I think that that's going to create a lot more pain points going forward than it previously has. On the flip side, M&A agreements in the midstream space generally don't have a lot of bespoke environmental provisions. You have your environmental reps and warranties, and that's it. That gives some degree of flexibility to actually try and adjust things in a way that might make more sense because you don't have any kind of market provisions you're stuck with that you have to work from in the background. But, there are still some other kind of nuances to it. Like I will tell you again, when we talk about what's considered market on scope of environmental due diligence in an upstream transaction, that's moving very much so in the direction of using the infrared cameras, doing overflights, a lot of remote sensing, looking for leaks. I will not say I have totally seen that become universal or near universal in the midstream space too. And I think pushing for that kind of enhanced due diligence in your access covenants is going to be really important, not necessarily because, we've done an overflight and we know how much we'll pay on the WEC, right? But that could affect whether or not, assuming we ever get a quad OB regulatory compliance exemption activated in our lifetime, that could affect the availability of that exemption, right? That plays into the WEC. I think it could also be useful for identifying potential super emitter events, right? And those do feed into your WEC obligation potentially. So making sure that you're not viewing environmental due diligence through kind of a static lens, I think is going to be really important going forward to account for these different obligations. And then, so how do we slice and dice this? In talking with some of my tax lawyers, and we still haven't gotten a totally complete, answer on this. Generally, taxes that are attributed to operation, right? You pick an effective time and you allocate them one side or the other. We can, again, borrow concepts like that from here. Can get obviously trickier based on when your transaction's occurring, how it's structured, things of that nature. But that's one very easy way to start drawing a line and then allocate the taxes, right? But again, we got to think about, okay, how do we account for the true-up component? Most of the time, I think this is really going to call for a lot of revisions, again, to our environmental covenants. Reps and warranties, that's usually the first thing in-house counsel and commercial folks will ask for. They'll say, we need a rep on this. We got to be protected from it. I don't think that's really going to be super helpful on this, because what it's going to say, one, we already give a rep on environmental compliance. So you'd be giving a rep, you calculated your WEC fee in compliance, right? I think the covenants are going to be a lot more important, because the covenants are saying, do this, do that in this way. And so if they fail to do that, that's how you gain a little bit more protection. Move ahead real quick to this last slide. Again, everybody always likes to ask me, what is market? As I kind of, indicated, there is no market here yet. And that provides a lot of flexibility, but also a little bit of a scary space, because I'm sure the first half dozen times anybody leads in a transaction with some WEC specific proposals, they're either going to get axed completely or scaled back significantly. And so we're going to have a little bit of a bumpy road as we try to figure out what's the best way to smooth over risk of post-closing disputes and ensure everybody's cooperating here, because cooperation is going to be needed, right? You're going to need to think about historical access to records and personnel, which can get really complicated when we're talking about asset transactions as opposed to entity transactions, right? And on the fines and penalties piece, a lot of our agreements, particularly those in the asset context, right, they have very strong provisions allocating pre-closing fines and penalties and responsibility. But the survival period that typically goes along with those, meaning how long does that protection really last for me? That's been shrinking over the past couple of years. And so, again, some of these I'm highlighting to, if this is a concern to your company, we're rapidly going to move beyond this is something the lawyers will be able to resolve, and you need to kind of put a stake in the ground that this is a material commercial issue and really signal that we're not going to just dismiss everything on this, and we have to work through some of these drafting issues. So with that, we got 7 minutes left. Ron, I will.
All right. Before we let you off the hook, there were a couple of questions that maybe fit in this line that came in online. First, a question from the midstream standpoint. Have you seen anything yet that gives you sort of an indication of whether midstream companies will try to pass through the WEC fee or tax or charge, I guess, depending on which term you want to use, under provisions that, for example, allow a pass-through for a new governmental tax?
So I got to give a shout out to one of my former mentors, Tom Merriweather, who's in the audience, because this may ring some bells for him. There was a project I worked on years ago where this exact issue came up in the context of acid rain allowances for power plants. And so the question was, can we treat our acid rain allowances as a tax that we can then pass through to off-takers? So a little bit different, but same basic concept, right? We looked into that, and it really is going to come down to some degree of contractual interpretation, like what specifically is in the agreement on taxes, how they are defined. Because here's the concern I have, Ron. While we call this the methane tax, and I'm not disputing that, what about for large air emission sources? Are air emission inventory fees passed off through tax provisions? The answer to that, I'm 99.9% sure, is no. So you can certainly try that, but if you're just relying on kind of general run-of-the-mill market terms on your taxes, I don't think you've got a smooth path to just pass those off through existing contractual provisions.
Okay. So again, kind of in the commercial space, There's obviously been a lot of industry consolidation going on. We'll see how well that succeeds, since almost every big deal seems to be now subject to an antitrust second level review. Sort of maybe a different topic for some of our other colleagues here at the firm. But in that context, do you hear people talking about opportunities for larger operators to be selling off assets, who may have some room not to report or may have some room to avoid the WEC? Is there, for lack of a better term, an arbitrage opportunity there?
I have heard lots of different operators considering that, particularly for like low production wells, right? Everybody is looking to offload those because you're going to have to report on them, you'll owe a tax on them, and they're really not a source of value for the company. That said, everybody's got to remember that when it comes to GHG reporting under the GHGRP, there are specific rules on how you get out from under that. And even coming under 25,000 tons per year basin-wide doesn't mean you automatically exit the GHGRP. And I think to Corinne's point, it's not clear what the effect of that is on your WEC obligation. I mean, because you're still required to report from that facility, even though the facility no longer meets the basin-wide definition. So it's going to, again, be a little bit of a bumpy road, and I don't think you should just assume divestiture is the solution or is a quick solution.
So this may be a little bit, we may take a pass on this, but there's one pretty specific one here. The greenhouse gas reporting program is going to now include methane slip from reciprocating engines as part of what you're reporting about. Any idea how this affects the WEC liability?
So I think this goes to the broader point that we were making earlier, which is EPA is proposing to bring a lot more sources in under their greenhouse gas reporting program, subpart W, which will serve as the basis for the WEC. So even if the calculations you have right now and what you're going to have to pay for the WEC don't look all that material or serious, when these changes go into effect, and EPA is proposing that will be in 2025, just as everybody's still thinks they're figuring out how the WEC works, that amount could really ratchet up fast, or you could realize that a lot of things that you hadn't previously thought that you were going to have to be measuring, you are now measuring and taking into effect. So again, every additional source that gets added potentially increases the amount you're paying under the WEC, and certainly increases the risk that you're calculating it wrong and that you're dealing with EPA enforcement.
Yeah, I've heard from clients that they're very concerned that including methane slip from engines is going to dramatically increase their methane emissions. Those aren't included now in subpart W. They will be included. Look, it's all site specific. It's all company specific. If the facility is totally electrified in terms of engines, you don't have this problem. But if you're out there and you're running engines to run compressors or for power or what have you, and you have this methane slip now from reciprocating engines, they could dramatically increase the amount of methane that is emitted from the facility. I mean, it's not a rule. It's not even a rule of thumb. But I've heard some people say that their methane emissions are going to go up by a factor of 3 once they fully implement the new subpart W rule from what they're doing today. I mean, nothing operationally will have changed. It's just the way that the new rule is going to require them to calculate. A lot of companies could see significant increases in calculated and reported methane emissions. And this is one, I think, particularly significant source that has never been counted before, and it will be counted.
So we're getting close to the end here. 2 really quick hitters. So there's been, at least at some early phases, sort of in my impression, a bit of lore and view and confidence. Well, this WEC thing is a short-term issue because the political deal that sort of materialized in the IRA was, okay, there will be this charge or tax, but once everybody is operating under Quad B and C, it can go away because we'll have all these very tight controls. Corinne, any of the three of you, you want to comment on the prospect of that coming true in that way? And whether this is a short-term or intermediate or long-term kind of thing folks are looking at?
So as I alluded to earlier, I don't think the exemption for compliance with Quad OBC is realistically going to give folks relief. The way EPA is proposed to do it certainly won't give you relief for a number of years. And even then, they are proposing that a single deviation or violation at your facility, anywhere at your facility over the course of the year means you do not qualify for the entire reporting year. And I guess my other skepticism is once you set up a government office to do anything, right? And once you have a bunch of auditors out there, third-party auditors who this is their livelihood, is this kind of program ever really going to go away?
There was one other just quick thing. There was a little bit of a question about whether we wanted to speculate on the prospects of legal challenges to this rule. Corinne, do you want to just talk a little bit about what has happened in the last couple of days in that the litigation challenge process has begun, although is deeply incipient at this point?
Yeah, so Texas challenged the Quad OBC rule on Friday, the day it came out. A number of environmental groups have asked to join into that case. We could see additional groups, either from industry, trade groups, other folks try and join in that case. We won't know for a little while whether or not they're going to ask the court to halt the rule while the case is ongoing. But I don't think anyone should assume right now that they don't need to meet those May 7th compliance dates based on that. And for these other rules, that is what we have tended to see is the day they come out in their final, somebody files a challenge to them.
Yeah, and as I understand it, some environmental groups have challenged as well, right?
So they've asked to intervene.
In the Texas, okay, so they potentially will intervene to say EPA got it right, but not challenge themselves. Okay. So we want to be respectful of the time. There were, I know, a couple of online questions that we didn't quite manage to pivot to. If yours is one of those, I apologize. We'll try to reach back out separately to try to take up that question. If you have any thoughts or reviews on this about whether it was helpful, whether it was not, things you would have, or things you would like us to do more on as to particular aspects of this, we'd appreciate any feedback. Again, either online or in person, we'll hang out. We may even have some formal written forms, but generally we just thank everybody for their time and interest and hope you've found this useful. We look forward to having chances to work with you if you should need some advice in this area. Thanks very much.